Coming to you live from the Now Media Newsroom.
I'm Jim Czek. You're watching Now Media. With me, Geoff Moyse from Moyse Law. Again, third time here, I believe, and that's great. And we've been talking about this case or what's going on in Richmond, but before that, it was Haida Gwaii. And the backstory on that may tell us a lot about what's going in Richmond. We talked about that last time and said maybe it's a good idea to go back and look at that case and that decision to kind of give us some relevance as to what's going on right now. I mean, packed town hall last night in Richmond, packed town hall, and Evie didn't show up, but Nikki Sharma showed up, but lots of questions and a lot of people with no answers.
Yeah, so a little bit of history for folks about the Haida situation. Of course, the name was changed not all that many years ago to Haida Gwaii from the Queen Charlotte Islands. That was, I think, done under the present government, but don't quote me on that. The Haida brought an Aboriginal title case to the BC Supreme Court some years ago. There had been attempts made at engaging in treaty negotiations with the province and federal government. Those really didn't go anywhere, I think because the Haida's expectations of perhaps of what they would get from a treaty did not meet their expectations of what they wanted to achieve on Haida Gwaii, which was, I think, something akin to almost a sovereign Haida title, an inherent title as it's sometimes described by the Haida. So treaty negotiations weren't going to do it. The Haida title case proceeded along, but at some point there were negotiations that took place, and I want to stress the fact the negotiations were bilateral. So the Haida were negotiating with the province of BC, the Haida were negotiating with Canada, but not at the same table. So not a trilateral process, and therefore obviously avoiding any allegation that they've done a treaty, which they do not, as I understand it, never did want to do. So double bilateral agreements, and we can talk a little bit about the sequence of how those unfolded.
Yeah, because this goes back quite a ways, and this was a Supreme Court of Canada decision, right, in November of 2004, I believe?
Well, what happened in 2004 is that the question of Haida's claim to title at that point was at issue because the province was reissuing a tree farm license. Haida said they weren't properly consulted about that and it infringed their claim of title. What the Supreme Court of Canada did very simply is to say, well, when title is asserted but not yet proven through a court process, the government of Canada, the government of BC are under an obligation to consult with the claimant and to accommodate their concerns if appropriate. So that's where the whole duty to consult and accommodate came from Haida in 2004. I do want to say one thing about that case, though. When it was in the chambers, the trial level division of the BC Supreme Court, the trial judge at that time, Mr. Justice Halfyard, had a lot of evidence in front of him about Haida's claim to title. He concluded, having looked at all that evidence, that the claim to title was a reasonable probability close to shore, within a kilometer of the shoreline. He said that the claim of title beyond that, inland beyond that, was a reasonable possibility, so no longer a probability. That gave the first indication that a judge looking at the evidence might not have conceded the notion that Haida title exists over every square inch of Haida Gwaii. So what happened next in the process on April 14th, 2024, the provincial government in the Haida announced that they had reached an agreement called the Rising Tide Agreement. I can't pronounce the Haida version of the name of the agreement, but if folks want to Google it, if you Google Rising Tide Agreement, you're bound to find it. one of the main things that agreement did is allegedly preserve the rights of fee simple owners on Haida Gwaii, while at the same time declaring Aboriginal title to the entirety of the Haida Gwaii archipelago. So already setting up Aboriginal title to be declared over private fee simple lands, not so different to Richmond. One of the things that's in that agreement, which is of note, is it says specifically it is not a treaty. The Haida did not want a treaty, and this agreement does not amount to a treaty. It's called a Reconciliation Act. I'd urge people to go to the Treaty Commission website, and you'll note there that in addition to treaty process, we now have a new process called reconciliation agreements, which are basically what the EB government is using now to negotiate Aboriginal title in various parts of the province, as opposed to treaties. The federal government on December 4th, 2024, did their own version of the Haida Agreement. They called it the Big Tide Low Water Agreement. It basically copies the provincial agreement by and large, with a few commentaries about federal lands on Haida Gwaii. Again, the agreement says it's not a treaty. Again, a bilateral between Canada and the Haida. In 2024, July of 2024, the BC government basically affirmed their agreement with the Haida in legislation. It's called the Haida Nation Reconciliation Amendment Act. And that's the provincial legislation that basically declared or purported to declare Aboriginal title for the Haida over the whole of Haida Gwaii. There's some question whether that legislation is actually constitutional. Provinces can't legislate Aboriginal title by themselves. Now, I think the province is hoping and relying on the federal government to pass a similar piece of federal legislation, which would have the effect of saving the provincial legislation from being unconstitutional. That has not happened yet. And then the last step I'll talk about in this process is that September 5th, 2025, the Haida issued a press release saying that they had just been to BC Supreme Court seeking a declaration from the court by consent of the parties to Aboriginal title now being declared over Haida Gwaii and recognized and affirmed under the Constitution of Canada, Section 35. So that's the last shoe to fall in the process today.
So in the Haida decision, though, it says it doesn't affect private titles? Is
well,
that
all of this is pretty much set out in two places. One is in an agreement between the province and the Haida, so that's a contract. The second one is the legislation. The provincial legislation goes so far as to say that estates in fee simple on Haida Gwaii are, quote, confirmed and continued. That's all it says. It doesn't say whose jurisdiction they're subject to. It doesn't say anything like that. The rest is contained in this contract where the Haida say, basically, we'll respect those private lands and private interests in land. We won't try and take them over. And you know, they're good. They're fine. Now, the problem with that, from my point of view, is they are good on the terms of a contract that the private owners didn't even get to enter into. It's not a contract with them.
Right.
It's a contract between the Haida and the province. And so my question is, what happens if the Haida, I know they're honorable people, but what happens if one day they decide to breach the contract? Then I think that all that's left is just the provisions in the provincial act about the fee simples being continued.
So then, is the property taxes that these people that have fee simple lands, are they paid to the Haida Nation, or are they paid to the BC government still, or who's collecting taxation there then?
I believe those properties still pay taxes to the BC government. The whole regime under under provincial legislation is supposed to continue. But my question is, if all the legislation says is that the fee simples are continued, a fee simple interest can be actually regulated by anybody. It doesn't have to be the province. It could be that the Haida turn around and say, well, we're taking over the regulation of these fee simples. We'll leave them as fee simples. But by the way, they're under our jurisdiction now, and we're going to tax them. And we're going to put potentially zoning restrictions on them as to what the properties can be used for, et cetera, et cetera.
Yeah, because people buy land or put houses on properties that are on First Nations land, like there's some in Kelowna here and that, and then they pay the taxes actually to the band, and then the same thing in Vancouver. There's some shorelines and that. But those are leases, right? Those are like 100-year leases or 130-year leases. Those are not fee simple lands.
No, they're not, and they're located on reserve lands, which are in essence federal lands held in trust for First Nations. So it's a completely different legal regime on reserve, and you're right, those aren't fee simples. The band can't agree to fee simples being issued over reserve lands, only things like leasehold interests.
So did the Richmond decision, did they use some of this, the decision to kind of, did that judge base their decision based on this and say that both titles can coexist? Because that's the part that doesn't make sense to me. There was a lawyer that stood up yesterday in the Richmond Town Hall and said that it can't exist, like the two titles cannot coexist. Right.
So what happened in the Haida judgment is Justice Young looked at Haida Gwaii and used it as an example, in her view, of why those titles can coexist. My view is that they don't really coexist. All that's happening is the Haida have demurred from claiming a right of present occupation over the fee simple lands. So it's not a question of coexisting, it's a question of the fact that right now the Haida have said we will not exercise our title over those fee simple lands. But the only guarantee of that is a contract with the provincial government.
So, I mean, that was a pretty heated town hall yesterday. And like I said, there was a representative there. Nikki Sharma was there answering some questions and said that the BC NDP are appealing that decision. So, and then she talked about extinguishment. You and I talked about extinguishment before, and she said that they basically argued something else that was very similar to extinguishment, and that they argued in the best defense of the land. So what is it that they're appealing then, and what, because the NDP's kind of like led us down this path as well with lots of, like private discussions and negotiations, and the landowners were never informed that this was going on. They just woke up one morning and said, this is what's happened.
Well, I think one parallel I would draw right away between Haida and Richmond is that I have colleagues in some of the big law firms in Vancouver who have canvassed some of the private businesses on Haida Gwaii and asked them what notice they had that their fee simple titles were going to be subjected to a declaration of Aboriginal title. I'm told that the only notification was those folks were asked whether they would agree to the province negotiating a reconciliation agreement with the Haida. It appears that's all they were told. And so again, I think no notification at all to the private owners that their properties were about to be subjected to Haida Aboriginal title, probably without their knowledge and likely without their consent.
The Richmond landowners there said they had no knowledge at all, and that the court was asked to inform, and then they were told that they did not have to. And there was even some talk that they won't be able to renew their mortgages. I'm not sure. I didn't confirm that, but any thoughts on that? Those people that have had this decision in Richmond.
Well, everybody's trying to dance around kind of two issues. First issue is, was there a finding by the court of Aboriginal title over the private fee simple properties? The answer to that question is yes. Was there a declaration from the court, which is basically an order of the court, enforcing that title over the fee simple properties? The answer is no. But when you go to the bank, you have to say to your mortgage lender, look, I am a hair's breadth away from finding out that the Cowichan have returned to court and asked now for a declaration of title over the fee simple lands. I don't know that that's likely, but it's certainly possible. And if that were to happen, then I think your value of your property would plummet immediately. I'm told, but this is anecdotal, I have no evidence myself, that that's already begun to happen in Richmond, particularly in respect of some of the private businesses there. I can't confirm that because it's anecdotal.
And I believe it's 780 acres, and there's a bunch of large businesses on these properties, and then the city of Richmond has some property, and then also some private landowners have some property there.
Yeah, it's about 800 acres. Now, 800 acres is about 234 hectares. I want to put that in some kind of context for you. 234 hectares of land compared to an Aboriginal title declaration for the Haida of 10,000 square hectares of land. So there's the difference. Now, the last thing I'll say about the Haida, they went to court with this consent order. Basically, the province and Canada agreed to the court agreeing to a consent order and formally putting Aboriginal title over Haida Gwaii. One of the things the judge was told, I understand, I wasn't there, but I've read the transcript. One of the things the judge was told was the evidence of Haida's occupation of Haida Gwaii was sufficient to form a basis for that determination of title over 10,000 square kilometers of land. The judge, as far as I'm aware, didn't look behind that curtain. So the judge was told that was the case, but I'm not sure that was ever reviewed. I may be wrong. I wasn't there. But if it wasn't reviewed, that I find very concerning.
And in the Richmond case, there's actually overlapping claims as well. There's 3 First Nations groups that are claiming title to this particular land, and then obviously the private landowners. Where does this end up? And I think last time we talked, you said this could take 5 to 7 years just to make it through the BC Supreme Court system before it even gets into the Canadian Supreme Court.
Well, it's going to go first to the BC Court of Appeal. That's later this year. I expect that all the parties, I think there are 7 parties I've heard of who are either intervening or appealing the case. I think there will be many more interveners who will be there trying to explain the ramifications of this finding. In terms of how long it will take, probably at least 5 years to get through the Court of Appeal and through the Supreme Court of Canada. There's no doubt it has to go to the Supreme Court of Canada given the issues. Andrew Petter, who is one of my former law professors at UVic from years ago, had a piece in I think the Vancouver Sun, I'm not sure, where he said, well, one thing that the province could perhaps do is go to the Court of Appeal with a reference case of its own, asking whether Aboriginal title and fee simple title can coexist. Now, of course, John Rustad of the BC Conservatives has said that reference should go directly to the Supreme Court of Canada, which would mean Canada would have to bring it. But BC is able to do a reference case to our own Court of Appeal. I thought that was interesting. Again, I'm not sure that a court that's about to hear the appeal would hive that off and say, well, let's make a judgment about this question of law before we've even heard any of the facts.
I mean, the Haida decision is fairly recent as well. And why did that one not kind of like stir up the hornet's nest like the Richmond case is stirring it up? What's the big difference when there's private lands involved in both cases? What's different in those decisions? Well,
remarkably, I guess what's different is that in the Haida context, the private owners have a contract that's been entered into between the Haida and the province, which they can allegedly rely on
Oops.
To keep their fee simple interests in property.
And we're just going to see if your connection gets better there. See if Geoff comes. There, you're back. I think you were just starting to answer that question and we lost you for a second. That's the first time we lost you this time. But maybe start again. The differences between the Richmond decision and the Haida decision.
Well, the basic difference is the Haida, the fee simple owners on Haida Gwaii can rely on a contract between BC and the Haida to keep their fee simples whole. In Richmond, there is no such contract as yet. So the Cowichan are in a position where they could tomorrow go to the court and ask for that declaration over the private lands. I don't think they would do that, but they're in a position to do that, which means I think that the fee simples in Richmond are somewhat more exposed than they are on Haida Gwaii. But again, I return to the main point, which is the only thing that's protecting those fee simples on Haida Gwaii is a contract.
Mm-hmm. And in the Richmond decision, did the judge not say that there was an 18-month pause there while they kind of like let this play out?
The 18-month pause is only in respect of the federal government and the federal government's interests in the Richmond lands. It does not apply in the case of the provincial interests. So there's no pause for the part of the judgment referencing private lands on the Richmond lands in the title area. The pause is only for the federal government.
So we had Jonathan Kay, and he's like a national journalist. I think he worked on the National Post and as an editor on the editorial staff there and everything. And he said that what's happening in British Columbia is kind of unique to BC and maybe Nova Scotia, where there's a lot of land claims there as well. He said I think you said that before too, a lot of Canada has treaties in place, whereas British Columbia has tons of overlapping claims, and much of BC could be subjected to this.
That's correct. BC is probably the most challenging jurisdiction in Canada, but New Brunswick, for example, has a massive Aboriginal title case going on right now. It's currently before the New Brunswick Court of Appeal. Same issue. Does Aboriginal title preempt private property interests in New Brunswick? I think the extent of that claim is over it's a huge area of the province. It might be 2/3 of the province, the entire province.
And maybe I got that wrong, Brunswick as opposed to Nova Scotia. But,
yeah, New Brunswick. The Maritimes generally have peace and friendship treaties. They don't have surrender treaties. A lot of the rest of Canada has those numbered treaties, so the issues probably aren't there for those provinces, Saskatchewan, Alberta, Manitoba. But they're here in this province big time.
I did interview Brenda Bailey, the finance minister for the BC NDP, and I did ask her about this decision as well, and said that this brings more uncertainty into the investment community of British Columbia, like buying property, buying land, or even developers. And she said they understand that, and they're going to vigorously defend the private land or the fee simple lands. So.
Well, I don't think they really have a choice now after this judgment. If they don't defend the private property interests, then I'm not quite sure who is going to. If the province doesn't mount a strong defense, then the Court of Appeal is going to look over at the other parties and say, well, why isn't the province arguing this? And that'll be up to the province to decide what kind of arguments they're going to put in front of the court this time. I'll say one thing. I know that the provincial argument, because it's been said in public now, the provincial argument was basically that Aboriginal title is suspended when fee simple titles are granted, suspended or displaced or both. And my only question about the provincial argument is that they didn't want to argue extinguishment because they felt that the 1997 Delgamuukw case in the Supreme Court of Canada had said provinces can't extinguish Aboriginal title from 1871 until 1982. But if they can't extinguish under the division of powers, how on earth would the province have the authority to suspend or displace. I mean, to me, it's the same problem. And if you're going to have the same problem, then you might as well argue the whole thing and argue extinguishment and challenge the Supreme Court of Canada to change their views on that.
Yeah, I think she did make that argument yesterday and said that they did argue just what you said there instead of extinguishment, and said that it's one and the same basically, and that they did argue it. But the Richmond mayor obviously is, he was pretty adamant and yesterday as well, and wanting something. I mean, he called that town hall. So, and the room was packed. And when you get a packed room, that people are worried. And there was even like some of the private landowners saying that they're going to start to lawyer up and start suing whoever they can sue. And I guess that person they can sue is the government of BC.
Ultimately, that's probably the case. I think that people should step back a little bit and take a breath on this one, because I personally am of the view that that judgment can't stand. I think it will be overturned. I'd be surprised if it isn't overturned immediately in the Court of Appeal. I don't think it can survive in the Supreme Court of Canada, because that court both of those courts are going to be practical enough to say, hey, we're all here to stay, and we can't have this kind of economic uncertainty, so we've got to sort this issue out right away.
It could decimate British Columbia in its current state. I mean, maybe there's a new state after this, but I don't understand how, if everybody's title, I mean, you wouldn't get mortgages, you wouldn't get, I mean, who's lending money? And most people have mortgages and then businesses and everything. So then, what do you say to the people that have those properties right now, though? I mean, they're basically in limbo. I think you talked about it last time. There's a cloud hanging over those properties, and that isn't moving away till a decision comes down one way or the other.
That's unfortunately true. I think the other thing I would say very quickly is that there is a misunderstanding, I think, about the geographic extent of Aboriginal title in BC. And one of the unfortunate things about the adoption of UNRIP is that the title definition in UNRIP is basically any territory you ever used, you own the territory, the land, and the resources on it. That is not what the Supreme Court of Canada has said about Aboriginal title. Their conception leads to much, much smaller areas of land likely to be found to be Aboriginal title lands. Well, that makes a huge difference to provincial certainty.
That comes up. That's really what came into play with this decision, though, too, right? Because it was just a land where they went fishing in the summer or something.
Well, the judge found that the presence of the Cowichan was sufficient occupation on a year-round basis to grant a title to that site, as opposed to just a recognition that the Cowichan fished there. She did both.
Lots of confusion for sure. Lots of confusion, and I guess the town hall helped. I guess to get some messaging out there. John Rustad has asked for the David Eby to halt all private negotiations that are going on. And I think you talked about that last time too, that these negotiations need to stop happening in private, because people waking up to finding out the news without any ability to defend.
So I would say quickly that there is no doubt there's a mandate in this province to do treaties. I don't believe there's a mandate for David Eby to be out negotiating Aboriginal title with anybody.
Sorry, we just lost you again for a second there. We're going to just wait till this clears up, and then we're going to start. There you go. We lost you again. You were just saying David Eby does not have a mandate, and I'll just let you pick it up from there.
I don't think there's a mandate to negotiate Aboriginal title throughout British Columbia. I don't think the public's ever been asked whether that should happen or not. And so, my fear is that he's talked about Haida being the template for other negotiations in BC. Well, if Haida's the template, then I'm assuming everybody's going to get their whole territory as Aboriginal title land.
Yeah,
that is just bizarre.
And then there's, I mean, I've heard some people say there's 150% of the lands because of overlapping claims of British Columbia that are up in question.
Well, there are, as I say, go back to the two Aboriginal, we've had 3 Aboriginal title cases in BC so far. One has found title to about 1,700 square kilometers of land in the Caribou. One has found title to about 11 square kilometers of land in Nootka Sound. And the third one, of course, is Richmond, which is 800 acres. Now, contrast that to an EB negotiation of 10,000 square kilometers of land over Haida Gwaii. Like, that's why we can't have the province negotiate Aboriginal title.
Mm-hmm. So how do we know? I guess we don't know how many of these negotiations are ongoing with the BC NDP right now. Like, how would we know?
I don't think you can. As far as I'm aware, they're all being done in secret and nobody's being told. I know there's a possibility of one coming in northwestern BC. I'm very suspicious about what's going on there on the QT. There's one coming for Seashelt in the Sunshine Coast. Have no idea what those will look like because nobody's being told, nobody's being asked to participate.
And then, getting some of these reversed, like say if, David Eby does a whole bunch of these before he gets, like voted out, I mean, getting stuff reversed is probably even harder than stopping it in the first place.
Well, you'll probably know that the lawyers for the Haida stood up in court and basically said they wanted a ribbon tied around these Haida agreements so that they could not ever be challenged by another government. So to the extent the federal government is going to potentially participate in Seashelt, northwestern BC, other places where the EB government is purporting to negotiate title, yeah, we could get the same result. Consent orders issued by courts making it all constitutionally affirmed Aboriginal title land for all time.
And the federal government has been relatively silent on this. I mean, even just, I know Pierre Poilievre of the Conservative Party has made some noise on it, but I haven't heard much out of the Mark Carney Liberals.
Well, I think that the Haida situation was done by Mr. Trudeau's government. And actually that doesn't surprise me terribly much, but I have no idea whether the Carney government is going to take the same approach. One litmus test, I think, is that there is no federal legislation, as I said, for the Haida Gwaii agreement as yet. And I think one indication of where we're going on this will be if the feds actually do legislate to make the provincial legislation constitutional. From what I've heard from Ottawa, there's been no move to do that yet.
So I'm sure you've heard a lot about the Richmond stuff. I don't know if you watched a lot of that town hall. What would you say, what's your summary of the Richmond town hall from last night?
Well, I think, I don't think there's any way around people feeling upset and worried. And I guess it's going to depend on what they're hearing from their bankers and other folks. I don't think there's any way around that. I know that there's lots of commentators who are saying, oh, don't worry about it, it's fine, Cowichan. They don't want your land, they never wanted your land. But remember that it was the Cowichan who drew their claim over those private lands. If they really didn't have an interest in those private lands, why were they not excluded from the claim? That's typically happened in other cases. They were excluded in the Chilcotin case. So, I'm a bit suspicious when somebody says, oh, we're not going after private lands, and yet you actually stuck them in your claim purposely.
They were specifically named.
Yeah, so I don't know what to make of that.
So other things any other takeaways you got from last night when the Attorney General spoke to Nikki Sharma? Any thoughts on what she had to say?
I guess the only takeaway I had is it appears to me that the Attorney General has said that Aboriginal title and fee simple title can and cannot exist at the same time in the same lands. I think that's a problem.
Yeah.
I mean, it's one or the other. So in the court case, originally they said they can't coexist. People like Tom Isaac, myself, Robin Younger, we've been saying this like broken records for a long time. They can't coexist. They're an exclusive right of use and occupation to whoever the title holder is. You can't have two entities holding exclusive use and occupation of the same piece of land. It's illogical and it doesn't work. But now, if today I see in the papers that now the Attorney General is coming out and saying, well, not only can they not coexist, but fee simple is actually the superior title to Aboriginal title. Now, I don't know where she got that from, how fee simple title can be superior when it's not constitutionally protected and Aboriginal title is, I don't know. But I'm just amazed at the comments. Now they can't coexist. So my question to the Attorney General immediately is, well, then what did you do on Haida Gwaii?
It's super confusing. That's what it is. It's absolutely kind of confusing, and the big problem for property owners that own property that put money in and they pay their mortgages, they pay their taxes, they pay all that stuff, is the bank is the first thing they ask for is a title. I mean, otherwise they're not going to lend you any money.
If you hold a mortgage, let's be clear about this. If you hold a mortgage, the mortgage company or the bank, they own your property.
Right. They have the title, actually.
They have your title, and you're allowed to live there while you make the payments.
Correct.
So you can imagine for them, this is a huge issue.
They've been relatively silent, though, because I haven't heard much. I mean, I guess maybe that's our, I'm sure they're not going to willing to say much, but I think perhaps we should pursue that and see what they're willing. I mean, somebody said in these comments, and I heard it last night in the town hall too, is, like they're saying that he could get a renewal on his mortgage, and the banks love certainty too. That's the biggest thing the banks want is certainty and somewhere to reach into somebody's pocket if things go south. So I don't know. The BC government could step forward and say they're going to guarantee the properties, but I haven't heard that either, though.
We haven't. I think the only I've been hearing from my colleagues who work in this area that things look pretty bad for the businesses in Richmond. That banks are already starting to show signs of a lot of nervousness around the veracity of those titles. People are losing value in their properties. I'm already hearing that from colleagues who are out there. The other thing is that the Attorney General keeps talking about, I guess when she finally gets in front of the Court of Appeal, she is now talking again about asking for a stay of this judgment. That is the best thing that could possibly happen to these private owners, because a stay of the judgment would mean it's not in effect.
Right. Yeah. But they could also guarantee the land, just like in a bank, say when a bank goes under, the government steps in and then backstops it, and they could actually come in and say, backstop, we will guarantee the value of your property while this goes to the courts, so that if somebody was to buy it, they would get that guarantee as well. I mean, that could happen, I imagine.
Yeah, but when you think about it, I've seen various numbers as to the value of those properties in Richmond.
Yeah.
We're talking much more than $1 billion worth in value, as far as I know.
Very, very high, yeah.
Very high. So I have a government that has a huge ballooning deficit. It's not in a position to come in and say, well, we'll cover a $1.5 billion worth of potential property liability in Richmond.
I think some people have put out there that it's close to $3 trillion of private lands that are held in British Columbia right now. I'm not sure who, even the Canadian government would have a tough time backstopping that right now.
Right.
So this thing continues to unfold. If people have questions, you worked for 31 years for the government, various governments, I guess, in Aboriginal law. So you have a lot of experience in this realm.
I did 31 years with 6 provincial governments, so I've seen everybody's political stripe over the years. I've been working in this area since 1991. My first file was to get into the NISCA negotiations for the NISCA final agreement. If people are concerned about this stuff, one thing I would really urge them to do is write to the government and say, get on with the treaty process and stop negotiating Aboriginal title, because Aboriginal title is not a good interest in land, particularly for anybody, I would argue, compared to the certainty that you get from a treaty over not only the nature of the ownership of the land, but who governs it and under what rules. It's all set out in the treaty.
And you're practicing now, kind of in a private capacity?
I am. Yeah, I'm basically advising business community and various people in that stripe. And I got a lot of experience in this stuff, and I know it inside out. So if people have questions, I don't mind trying to answer them as well. If they want to reach out to me, I won't charge necessarily for the privilege.
So the Richmond decision, that's like 800 or so acres. There's questions last night that some of the surrounding areas might be affected as well. Is that? I guess. Well, I mean, all of it is subject.
I would say not at this juncture. I think it's where the lines are drawn on the map. But I would say I have heard, and again, this is anecdotal, I don't know if it's true, that Cowichan are going to appeal as well to get the remaining 1,000 acres that was left out of their title declaration by this court.
1,000 acres in the Richmond area would be huge, though, too, right?
Well, the original claim was somewhere around 1,800, and I think I've heard that the Cowichan are planning to go after the other 1,000.
And then there's 2 other First Nations that were also challenging in that area as well.
Well, that's right. And Tsawwassen and Musqueam, we have a classic overlap situation. It exists in lots of places in this province. Overlapping claims, overlapping territories, shared territories. And of course, Musqueam are basically saying, that's not your land, it's our land. Tsawwassen basically saying the same thing, at least historically. Remember, Tsawwassen have a modern day treaty now, so they're not in a position to assert Aboriginal title to Richmond anymore. But nonetheless, historically, they can still say, it was ours at the time, or we were there, and it shouldn't have been declared title land for the Cowicans. So there's lots of balls in the air.
Well, as usual, I thank you for your time, and I'm sure this is not going to go away in any short period of time. I think this is going to take a while to play out. It'll be interesting to see what the NDP's next steps are, even in their PR, like how they message this to British Columbians, because this one is not looking good on the BC NDP right now.
Well, there's the last thing I'd say is that there's a lot more baggage out there that this government has brought to bear than just the stuff we've been talking about. There's all the baggage they've brought in with the DRIPA legislation and saying that they're going to align all BC laws with UNRIP. UNRIP is just a pile of jello compared to a provincial piece of legislation. Anybody can interpret UNRIP in many, many different ways, and I think the government is over-interpreting it to some extent, which is adding a whole another layer of complexity and uncertainty on top of the constitutional law structure we already have for reconciliation. So I think personally that's a big, big problem in this province.
How big of a role does the government play in this, though? Like if, say there was an election tomorrow and the Conservatives won, how big of a role, like some of these are in the court system, which is outside of the government, how big of a role is the BC NDP? Are they leading this, or are they just kind of like letting it happen, or what is their role, and how could a changing government change what's happening?
Well, I would say that the court cases are a very tiny component of this. And you're right. I mean, all that can change in terms of a court case is what's argued in front of the court. You can't necessarily dictate the outcomes because the courts will dictate the outcomes. it's only a tiny part of the whole landscape, though. The government's so-called reconciliation agenda is based entirely on UNRIP. And it's not based in Section 35, which is our own constitutional structure for reconciliation. We're the only country that has this kind of constitutional affirmation of Indigenous rights. And yet we somehow feel we have to go beyond it into the world of UNRIP, create more confusion, more uncertainty. The Land Act was a good example. Now we have the Heritage Conservation Act. These are all being done under the auspices of UNRIP. So my advice to a future government who found all of that somewhat problematic is just pull it back, repeal DRIPA, start again, and operate under the Canadian constitutional law precepts that we already have.
As usual, Geoff, very informative and in a very confusing kind of thing. And I'm sure the people in Richmond are super confused as to what's going on. We saw that in the town hall last night. And,
I think I will probably convey to you that I'm super confused as well.
I mean, it is super confusing, like what you just said, what the Attorney General says, says this one day and says that the next day. And then, that's the people that are kind of like making decisions for us. And then this is before the courts. And there's already enough uncertainty here in Canada just in investing, and this surely doesn't help. And again, Brenda Bailey acknowledged that this doesn't help developers, developers when they're choosing to develop here or Alberta or the United States, you're going to go where there's more certainty, and it would behoove them to do this in the most expedient way.
Well, I think the other thing that needs to be recognized is that this province was built on top of Indigenous people's interests in land, and that situation has not yet been squared. Like we're still going through these motions and not necessarily solving the problem or the challenge or the opportunity, depending on how you look at it.
Well, I'm sure we'll talk a few more times. Again, very appreciative of your time. And if people have some questions for Geoff directly, you can go to moiselaw.ca. I believe that's what it is, moiselaw.ca. You can find Geoff's email address, and you can ask some specific. There's a website. We just pulled it up there for you. I think the contact information is there on the bottom. There you go. A big blue contact button. Can't miss it. And lots of experience in this area. And again, if you have questions and you're concerned about your property, reach out to Geoff. And hopefully we get an expedient decision, which I doubt will be expedient, but
well, I just hope and pray we get a stay from the BC Court of Appeal, because that just basically takes us back to before the judgment was issued, which would be very helpful given the uncertainty that's been created.
But it still leaves that cloud hanging over those properties. Even if they get a stay, it would be still a tough sell, wouldn't it? To be like if you're saying, well, okay, I'll take that stay and opportunity and I'll sell this property to somebody else and let somebody else worry about it. The value of that property is already probably diminished.
The value would still probably be negatively affected. The only thing you could say to your mortgage holder is, look, it's been stayed for now, so the situation is status quo, and there's every chance that it will be revisited on appeal. So, but yeah, could it still have an effect, negative effect? Yes, for sure.
All right. Again, thank you, Geoff. Thank you very much for your time, and I'm sure we'll chat again. And thank you for watching Now Media.
You bet. Thank you.
We don't just report the news. We live here too. We're your neighbors, bringing you stories that matter to all of us. No government funding, no outside influence. Kelowna Now, local, independent news.